Hello, this is attorney Brian Pendergraft of the Pendergraft Firm LLC, and today's video is on the Maryland Real Estate Statute of Frauds, and that is Maryland Real Property Code Title 5. What I have in front of you, you see pulled up right here, is Section 5-101, and we'll be going all the way up to Section 5-108 in order to cover the entire title. Let's see, and I have, let's see, if you would like to follow along, I have the link to 5-101 in the description. And, but as you see, if you pull it up, you'll see your version won't be color coded like mine. I like to color code mine to, I guess, kind of make it easier to follow along. So what the statute of frauds actually does is it's really simple. As the name implies, the statute of frauds is designed to prevent fraud. So this was a common law principle that was created hundreds of years ago, long before Maryland was around. And Maryland has created its own statute of frauds. And like the original statute of frauds, the Maryland statute of frauds requires contracts in land to be in writing to prevent fraud. So what this means is that if you want to buy, sell, or lease real property in Maryland, that it should be in writing. And the Maryland Real Estate Statute of Frauds also has things to say about real property trusts that I will also be covering as well. So here are a few caveats. So this is legal information. This is not legal advice. For legal advice, you can contact a licensed real estate attorney. So if you say you need purchase and sale agreements or leases that are compliant with Maryland law, so you do not wish to run afoul of the statute of frauds, you can contact a real estate attorney such as myself. My contact information is in the description below if you would like to consult with me. And another caveat, this video was taken on November 27th, 2019. So by the time you watch it, this video may possibly be out of date. The law changes, the law changes. So keep that in mind. And lastly, let's see, if you like this kind of content, please like and subscribe so I can, keep making videos like this. And if you're thinking anything, feel free to, drop comments. Comments are great. If you have any questions, feel free to drop comments. All right, so let's get into it. So starting with Section 5-101. So this says, every corporeal estate, leasehold, or freehold, or incorporeal interest in land created by peril. Okay, so let me go ahead and let me go ahead and stop right there. So what this is saying is that every corporeal estate, leasehold, freehold, so any type of land you can think of, whether it's something owned in, let's say, fee simple, which is that's just regular ownership, or let's say leasehold. That would be leasing. So what from anywhere between, I guess, on one hand, leasing someone else's land, on the other hand, outright ownership of the land, and everything in between. That is what this covers. So any interest created in land by peril. So what does peril mean? So peril means orally. That means an interest created orally. So if an interest land is created orally, now let me keep going with the statute, and not in writing and signed by the party creating it, or his agent lawfully authorized by writing, so if it is an interest in land not created by writing, so an interest in land created orally. So let me break this down even further. So oral agreements regarding land has the effect of what? Now let's continue to see what the oral agreements regarding land, what do they have the effect of? So it has the force and effect of an estate or interest at will only. So I got to break down what at will means in a little bit. And it has no other or greater force or effect either in law or equity. So again, so what this means is that the most you can create orally would be an at will interest. That can be, so if something is at will, that means it can just be terminated at will. Terminated at will. So here's an example. So if I let's say lease a orally agree to allow someone to stay at my property, uh, that means that person that I've allowed to stay at my property, they have an at will interest. So then I can terminate that interest or terminate that tenancy at will, meaning that all I would have to do in order to terminate their interest would be to give them a, let's say, the minimum amount required by that particular jurisdiction, or by law in that particular jurisdiction. So it may be a 30-day notice, it may be a 60-day notice, depending on where you're at in Maryland. But I can just, as soon as I give that person, that 30-day notice, that 60-day notice, or whatever that required notice is, I can terminate their interest and they have to go. But that is why, let's say if you're a tenant in particular, that is why, you definitely want to make sure that, whatever interest that you have is in writing. That way you can, you can stay longer than the will of the person who, allowed you to stay there. All right. So moving on to section 5-102. So this section 5-102 states that section 5-101 of this title is not applicable to a leasehold estate not exceeding a term of 1 year. Okay, so what this is saying is that there is an exception to what I just said in 5-101. So, and there is that exception, and there is that one exception. So here, essentially, the statute of frauds does not apply to a lease to an oral lease that is shorter than 1 year. So if you have a oral 9-month agreement, or oral 10-month agreement, or even an oral 11-month agreement, then that can still that is still effective and not subject to being terminated at will. If you can prove that that agreement was created, which is probably another loophole, that's another endeavor in and of itself. But if you can prove it, then that is enforceable. So that is the one exception to the statute of frauds. Moving on to 5-103, and that is this red section here. No corporeal estate, leasehold, or freehold, or incorporeal interest in land. All right, again, so let's keep that simple, right? So there's no no interest in land, whether it's on the highest form of ownership, that would be fee simple, or let's say the lowest form, you're just leasing it from somebody else. So no interest, and everything in between. So that interest. No interest in, let's just say real estate, in land may be assigned, granted, or surrendered unless it is in writing signed by the party assigning, granting, or surrendering it, or his agent lawfully authorized by writing or by act and operation of law. So what this is saying is that these interests, it may not be assigned, it may not be granted, it may not be surrendered, unless that person, the owner, or the assigner, it may not necessarily be the owner, maybe the assigner, or their agent. Their agent can do this as well. So if they have a power of attorney, they have the power to assign. Let's call it. They can assign this interest or grant an interest, but it must be in writing. That is the key. Or by act and operation. Again, or it says or by act and operation of law. So again, so what that's saying is that by operation of law, meaning that a court can assign the law, or a court can assign an interest in land. So they're able to do that. But as far as you and I are concerned, if we wish to assign, or if we wish to assign, or to to buy real estate from somebody, it needs to be in writing. Okay. So moving on to 5-104. That is this, and we're going to this blue section here. We're blue now. So no action may be brought on any contract for the sale or disposition of land, or any interest in or concerning land, unless the contract on which the action is brought, or some memorandum of note of it, is in writing and signed by the party to be charged, or some other person lawfully authorized by him. Let's break this down. Let's break this down. That was a lot. So let me just divide this into little parts. So no action may be brought or any contract for sale or disposition of land or any interest in concerning land. All right. No action. So in other words, lawsuit. So you can't sue somebody unless the contract in which the action is brought or some rather no is in writing. So you can't sue somebody regarding land unless it is in writing, signed by parties to be charged. So in other words, the party to be charged is that would be the buyer. I mean, I'm not the buyer. That would be the seller. Essentially, no, I probably shouldn't say the seller. That can be either party. Actually, that can be the buyer or that can be the buyer or the seller. Essentially, I mean, you know, yeah, I shouldn't have said that. That could be either the buyer or the seller. So either of these parties can bring an action essentially. So but in order to bring an action, it must be signed by both parties essentially. So you know what? That's probably not even the best way to word it. You know what? That probably is the best way to word it now that I think about it. It should probably be signed by both parties in order for you to try to sue somebody for a yeah, I think that's the best way to interpret this, or the best way to word this. Essentially what this is saying is that if you want to sue someone for a, let's say a contract to purchase land, if I want to sue somebody, and let's say I am the buyer and I want to sue the seller, but if the seller didn't sign the contract and it's not in writing, then yeah, then for me to try to sue him, you know, this statute here prevents me from doing that. So that's what that would do essentially. So again, what this is saying is that if you want to sue somebody regarding a real estate contract, regarding the, again, this is about the sale or disposition of land. So this isn't necessarily the leasing of land. This is particularly the sale or disposition. In this particular case, you know, if I want to, again, if the buyer can sue the seller or the seller can sue the buyer, if there is a writing and if it is signed by, you know, by the buyer or seller themselves or one of their agents. All right, so moving on to 5-105. So let's get the section here in yellow. So except as provided in section 5-107 of this title, which I guess we'll get to in a few, about two skips over because we're at 105 right now. Every declaration of trust or amendment to it respecting the land shall be manifested and proved by a writing signed by the party who by law is enabled to declare the trust, or by his will in writing, or else it is void. All right. So what this is saying is that let's say a land trust or a revocable living trust, in order for it to be valid and not void, there must be a writing signed by the, let's say, the grantor or the person who has the legal authority in order to authorize the creation of that trust. And that can be done either they can just say declare the trust themselves while they're alive, or they can do it via last will and testament. That's another way to declare a trust. All right, so moving on to 5-106, this purple section here. Every assignment of any beneficial interest in a trust. So this is saying that if you want to assign an interest in a trust to someone else, the assets of which wholly or partially consist of land is void unless the assignment is in writing, signed by the assignor or his agent, lawfully authorized by the writing. So the assignment of an interest in trust, it must be in writing, and it can be done by the assignor, or it can be done by their agent, but they must do it in writing. Or two, the second element, it can also be done by last will in writing. So a will that that assigns an interest in the trust, essentially. That can also that is also an effective way to for an assignment of a interest in trust. All right, so moving on to 5-107, that is this yellow section here. This title is not applicable where any grant is made of any interest in land by which a trust arises or results by implication or construction of law, or where a trust is transferred or extinguished by operation of law. So let's see. All right, so this is saying that this particular section, or the rules for the creation of a trust that I just I mean, that's creation of a trust, but of the assignment of an interest in a trust, um that I just went over. It's saying that it is not that law does not apply to, let's say, trusts that are created by construction of law, or say for example that let's say an example of trust created by construction of law. An example of that would be a trust created as a result of legal action or something like that. In that scenario, that trust is still valid even if it wasn't created under the rules that I went over with previously. All right, so moving on to section 108, here is our conclusion. Nothing in this title may be construed as negating any additional requirement of this article for the effective granting of estates or interests in land. So what this is saying is that nothing in this title may be construed as negating any additional requirement of this article for the effective granting of estates or interests in land. So so what's a good way to word this or translate that into English? Let me think about that. So what this is saying is that you can't just look at one particular requirement and think that it negates another one for granting or creating an interest in land. In fact, it doesn't do that. It doesn't do that. All those additional requirements must still be met. All right, so there you have it, and that is the Maryland Real Estate Statute of Frauds, Section 5-101 through 108. We got through it. I think maybe I was a bit rocky at some parts, but hopefully you understood me. If you didn't, I guess I'll do better in the next video. Anyways, please like and subscribe. And again, if you want to be compliant with the Statute of Frauds, feel free to. And you need contracts. You need great contracts for the state of Maryland. You need the best contracts. You need good contracts. Feel free to shoot me a message. Hit me in my DMs. Feel free to subscribe as well. And thank you for watching. Let's see if I can get this video to cut off now. I'm trying to cut off this video. And we're done. Peace out.